Well, nice to have you out there, and welcome to the program. It's always a pleasure to be here, and of course, always I'm happy that you're out there watching. I'm going to have a little different program this time around. I've got a film that we did a number of months ago, and I think it's very important. It was with my guest, attorney Paul Abreau, and it's about mortgages and notes. We're going to run that film, but before we run that film, I just want to let you know of a new case that came, the case that I read, and a very interesting part of the case is what they call a power of sale. Now, when someone gives a mortgage, so in other words, if you own a house and you want to borrow some money, especially from a bank, they're going to want to have what they call a mortgage on your house or property. The mortgage basically is a security. So if you don't pay the note, in other words, if let's say you borrow $100,000 and for some reason you don't make payments, eventually what they'll do is they'll move against the house by foreclosure. So the property is used as security to back up the loan. You don't pay the loan, they go after the property. It's something that's very common, actually. You know, you see it all the time in the newspaper. If you read the legal notices, you'll see where it has the notification of foreclosure. Usually you'll see the heading, mortgage. They'll identify the owners of the property. They're going to identify where the property is. Usually there'll be a legal description, and they'll have whoever or whomever the money is owed to. It could be a private lender, or it could be a bank, it could be a mortgage company. And what they usually have also is who is the party foreclosing. Usually it's an attorney. They'll put the attorney's name, of course, address, telephone number, so that if when you read the notice, if you're interested in a property, you can go view the property, or, you know, of course, on top of that, you can call the attorney and get additional information, hopefully. But this little thing I'm going to read came out of a case that I read, and it concerns what they call a power of sale. So when you give the mortgage, you have the mortgage, then you have a note. The note usually has the term of the mortgage, the loan, the amount of money that has to be paid per month. It's usually a monthly payment. And the interest rate. So it might be for 30 years, 4.5%. And of course, you know, they want to identify the property. But in there, there's what they call a power of sale. So usually, if what happens if you don't pay the mortgage, you're not paying on a note. There is what they call a statutory power of sale, which means that the lender, under the law in Massachusetts, can move to foreclose. And what this basically says, I'm going to read it, is that a power of sale that I just mentioned in any mortgage of real estate shall not be exercised, and an entry shall not be made, nor possession taken, nor proceeding begun for the foreclosure of any such mortgage after the expiration, in the case of a mortgage in which no term of the mortgage is stated, 35 years from the recording of the mortgage. And this is basically a statute of repose, so that if no action is taken after 35 years, that's going to be pretty much the end of the mortgage. Usually no one waits 35 years. If you're the lender and payments haven't been made, I don't think you're going to be sitting back for 35 years and then, you know, in the 36th year, decide to foreclose. So that's pretty interesting, especially for people, you know, who are in this type of a business. And in the case of a mortgage in which the term or maturity date of the mortgage is stated, then it's a 5-year period from the expiration of the term or from the maturity date. So this is pretty important. I thought I'd let you know. And we're going to get into the, we're going to go into the film now. This is Attorney Abreau and myself. I interviewed him. So let's start the film and see what we have. Once again to my program. It's always a pleasure to be here. It's always a pleasure to have you out there. I have a guest who has been on my program a number of times, and from the viewers out there who have talked to me about the program after watching it, of course, have said they get a lot of good information, a lot of good information. Well, my guest is an attorney, and he practices of real estate, land, law, things of that nature, closings, mortgages, draws up deeds, does title searches. Very interesting area of the law, and very crucial, because of course if you're out there looking for a piece of property, first thing you want to do is you want to make sure that you know what you're going to buy. And the thing is that before you buy the property, you want to have a title search. We're going to talk about what a title search is. And from the other side, as a seller, you'll need certain papers. You'll need a purchase and sales agreement. You might list the property with a broker. You might try to sell it yourself. So these are the different things that we'll be talking about. And welcome, Attorney Paul Abreau.
Thank you.
How you doing? Good. Glad to see you again.
Thank you.
A nice suit. You're looking good.
Try to look my best for you, Richard.
Yeah. Must be prospering. Well, let us, first of all, let the audience know where your office is.
My office is up in Norton, and I do pretty much cover eastern Massachusetts as far as doing real estate closing. I represent lenders, individuals, usually in real estate transactions, whether you're buying or selling either side, or representing the bank in doing the closing for the mortgage.
Represent developers?
Not so much that.
Not
no.
so much.
Pretty much the buyers and the sellers. And,
get involved with looking over a purchase and sales agreement?
correct, yep.
What is a purchase and sales agreement for the benefit of the audience?
The purchase and sale agreement is your agreement to, if you're the buyer, to buy the property from the seller on the term. You've already done an offer. So the offer is usually a 1-page or 2-page document. When you go to see the house, you're all excited on the weekend on a Sunday, you love the house, and you're like, I want this, and you sign an offer saying to the owner of the property, I want to buy the house for this price, and I want to close on this date. Close means to purchase the property on a certain date. And you might put in the offer that it's subject to certain things like a home inspection, or if there's a septic system, subject to Title V, subject to getting a mortgage, things like that. Agreement.
So that might be accompanied by a little deposit?
Right. So with the offer, you usually put down like $500 or $1,000 just to show that you're serious.
So it's a temporary,
Right. Kind of like holding your spot. You know.
And if you don't go any further, you could forfeit the $500?
You could. It's pretty unusual that you lose that deposit. It's usually not worth fighting over the seller. I usually tell sellers if the buyer backs out, you know, just release the deposit and market as soon as possible.
Now, if there's a broker involved before the property goes on a market, usually there's a listing agreement?
Correct. So if you're the seller, you have a listing agreement with a broker, and that usually spells out like what commission you're going to pay when the property is sold. So it's usually a percentage. A lot of times it's 5% of the purchase price, but, you know, talk to the agent as far as whether you can negotiate that. And then it will spell out as far as how long the listing is for, the agreement for. A lot of times it's 6 months to market the property and try to sell it. And then after those 6 months, then you won't be using that office if you don't extend it.
Now, typically in a listing agreement, is there a clause? I've seen it in a number of these listing agreements that the broker will be entitled to a commission if the property is sold to someone he has shown the property to?
Correct. They need to protect themselves, the agents, as far as, say it's a 6-month agreement. If they show the property to somebody and that person comes back after the agreement is done because maybe wink wink with the buyer, like
Okay.
I'll come back after 6 months and maybe we just split what you were gonna pay for a commission, you know, reduce the price by a little bit.
The seller
what you were
could have
gonna
a
pay.
problem?
Yeah.
Now, is it good practice for the listing agent to give a notice to the seller? I've shown his property to so-and-so, this is their name.
Yeah, usually agents keep a record of who they've shown the property to, so they keep go and check and say if there was a transaction after the showing, after the agreement, then they could go back to the seller and say, we introduced that person to the property.
All right, so here you have a person owns a piece of property, seller, and the first piece of paper that might pass is the offer, and then of course, well, that what precedes that would be the listing agreement,
Yeah.
and then the offer might come up. Purchase and sales agreement, which
Right.
is
Which is a longer document, might be 6 pages, 10 pages. And purchase and sale agreements are usually very standard documents. We all, attorneys or realtors, have standard forms in our computers that we use for transactions, and then we change the terms, obviously, based on, you know, whatever the parties have agreed to as far as the price and the dates and things like that. Where purchase and sale agreements are usually negotiated between the parties is if there are inspection issues, because usually between the offer agreement, so the buyer does a home inspection, will hire a professional home inspector to look at the property, see if there's any issues that maybe the buyer didn't notice when they looked at the house and needs repairs, and then they negotiate with the seller on those repairs.
and that gets put into the purchase and sales agreement.
Correct.
So if the home inspector tells the buyer, look, the chimney on this property is really, you know, the bricks are loose, the mortar is powdery, you need extensive work, you should go out there and get your.
Right.
So that will then be put into the purchase and sales agreement, subject to.
The chimney being repaired, if the seller has agreed to it. Because the seller could always come back and say, no, I'm not going to do it.
It's
You know,
as is.
It's as is. The price reflects that the house needed repairs, so that's the way it goes. And then you as a buyer, you can say, well, I don't want to buy the house with that problem, or you do buy the house. It's all negotiation. There's no right or wrong to it. And there's a couple of ways you can handle inspection issues, because you might repair. Maybe you want to do the work yourself, or you trust somebody to do it the right way, so maybe you negotiate with the seller price credit, you know, say reduce the price by X amount of dollars, and then I'll take care of the repair. So a lot of people do that too.
So once the purchase and sales agreement, it's a negotiable instrument in the sense that you can negotiate, not that you can pass it along.
Right.
But, so there's this back and forth.
Mm-hmm.
And once an agreement is reached, both parties sign.
Yeah.
Broker traditionally signs too?
They're not looking for brokers to sign it.
All right,
In
so
the past, brokers used to sign them, but now usually.
was that more or less to protect their own commission?
Right, yeah. protect their commission, maybe just to make sure who's the parties to the whole transaction. But recently, I have not seen brokers signing purchase and sale agreements. So.
Now, the purchase and sales agreement, it seems like a fairly technical piece of work, but it doesn't have to go before, or be looked at by an attorney. Is that correct?
Well, most people do have an attorney look at it
At
nowadays.
that point.
Yeah. There are terms that you want to make sure that are in the contract. Whether you're representing a seller, there's certain things that you look for, or whether you're representing a buyer, there's certain things you look for to make sure like your deposit is protected. Because when you sign a purchase and sale agreement, now with the offer you put down that small amount of money. With the purchase and sale agreement, you put down a much larger deposit. Sometimes it can be 5% of the purchase price.
So if it's $100,000, that would be $5,000.
$5,000. So that's a good amount of money that if you don't perform the contract, you can lose that money. The seller can keep the deposit for some reason, then they can keep the deposit. There are things in the contract that protect you, like if you cannot get financing by a certain time, then you can get out of the agreement and get your deposit back. But you can't just change your mind and say, oh, I found another house I like, so give me my deposit back.
Could forfeit the deposit.
Yeah.
Deposit generally held by who?
It's usually held by the listing agent's office.
Put in an escrow account?
In an escrow account. Sometimes, if there are no agents, because you don't always have agents involved.
Could be a private...
Attorney would hold it. Usually the seller's attorney would hold it. But either attorney would hold it in escrow.
Oh, all right, so the purchase and sales agreement is reached, both parties have signed, and you're dealing with the, we'll say, the buyer of the property. Next thing, title search?
Next thing, you have a title search done.
And the purchase and sales agreement is subject to a title search?
Right, so the purchase and sale agreement will say that it's subject to the seller giving you clear title to the property, so that there are no liens in the property with the title as far as all the deeds have been transferred properly in the record. So it depends on the buyer as far as the title exam goes, whether you're getting financing, a mortgage, to purchase the property. Then the bank that you use will hire an attorney to do the closing, and that attorney will do a title search on the property. Or if you're doing a private deal with no mortgage, a cash deal, a buyer will hire an attorney to do the title search and do the closing for them.
Okay, and you do title searches and you do closings. So
Right.
If it was a private action, you take care of all that paperwork for the buyer
Right.
and the seller?
Yeah, so if it's a private transaction, usually the parties have attorneys for each side.
Each side.
So I would do, if I was representing buyer, I would do the title exam, and then I would handle the closing, which on a purchase, for a cash purchase, it's much simpler. There are a lot fewer pieces of paper that you have to sign on the closing.
No mortgage involved?
No, so, but you have a simple, somebody has to be doing the settlement statement, breaking down the numbers between the two parties and kind of dispersing the money. Maybe he has to take care of paying off that mortgage. So that's why you need somebody to handle the actual closing. But it's much simpler than the mortgage closing.
Well, let's say that there is, it's a private sale, but the seller has negotiated or spoken to the buyer about some financing.
Mm-hmm.
When financing is done on a piece of property, it's generally called a mortgage. Is that correct?
Right. So
What is a mortgage?
So the mortgage is the security for to pay back the other person, so the lender. So a mortgage can be a private mortgage. You could give me a mortgage so I can go buy a property, and you might be lending me $100,000. Well, you want security that you're going to get that $100,000 back. So you say, Paul, give me a mortgage on the property that you buy, so that if I sell the property, you're paid whatever is due on.
And that's called the first mortgage?
First mortgage, yeah. Whoever's on record first
Is
first. Goes in order. It's just whoever's at the registry deeds.
Now, Of course, there have been situations where someone is granted a mortgage on a piece of property and neglects to record,
Right.
or didn't want to record for some reason. What's the pitfall in not recording a mortgage?
Well, the risk with that is that then the person that owns the property could go out and get another mortgage from a regular lender or another person, and that person puts the mortgage on record. So they would be, if you were just holding that mortgage in your pocket, and you're like, oh, I forgot to do that, and I run down to the registry of deeds, well, you're behind that first mortgage.
And
So the
that's not
problem with
good.
that- No, if there's no equity in the house, so, if the house is only worth 100,000 and that first mortgage is 100,000, you'd be out of luck as far as getting any money if you wanted to foreclose on the property or if the property's sold.
Now, along with the mortgage, now is there any kind, people speak about what they call a note, a promise.
Yep.
Explain that for us.
The note is your promise to pay the bank. So you're making a promise to the bank or the lender, if it's a private person, that I will pay you back, say, $100,000, and it will say what the interest rate is, whether it's a fixed rate or adjustable, the monthly payments, the term of the loan, how many years it's going to take for you to pay it back is negotiated, and that's all in the note, and that's your promise.
So the note is basically more specific
As to
than
the
a
terms.
mortgage
Correct.
itself. The total amount of money that.
Right. The mortgage does not show the terms of the loan as far as like the interest rate, your monthly payment. The mortgage will show how much the loan is for and how many years it's supposed to be for. The mortgage is because the lender doesn't trust you. They like your promise to pay, but they don't trust you.
But
So
they
the
want collateral.
So it's the collateral. So the mortgage is used so that if you don't complete your promise to pay back the loan, the mortgage is used to foreclose on the property.
Now, and you can expound on this in the mortgage in regards to what they call the statutory sale.
Statutory power of sale.
Yeah, what is that?
That's giving the lender the right to sell the property if you do not perform the terms of the note. So if you default on the note, and we talk about basically that you didn't make your monthly payments on the mortgage as the default, but there are other ways that you can default. Maybe you don't pay your taxes, so then there are real estate tax liens on the property.
And does that come in?
Mm-hmm. In the note, you're making that promise, and then the mortgage also is saying that you will perform these things as far as maintaining the property, pay the taxes, pay the insurance.
Okay,
like
so that could be in the mortgage itself.
Yeah.
And then it could be repeated in the note.
Right.
So the statutory power of sale is by statute under the, we'll say in Massachusetts, you'd go to the foreclosure statute insofar as the process and procedure.
Yeah. There's lots of procedures that a lender has to go through, especially rules, so that to protect homeowners that have gotten themselves into difficulty with a lender. So the state has increased notice requirements. The basic thought is they want lenders to work with homeowners if they're in default to try to work it out some way, somehow. So there's almost like a cooling off period as far as like giving the lender and the homeowner a chance to work it out. Maybe they extend the loan to make the payments cheaper, or reduce the principal balance, or reduce the interest rate. Different ways. If
So-
all the then the bank can foreclose on the property, and then there's notice requirements, and that's when you see notices in the newspaper saying that there's an auction.
Foreclosure,
gonna be,
yeah.
and there's all the procedures for that, which is rather complicated, but at the end of the day, if they follow all the procedures, the bank ends up, or the lender, because a private person can do a foreclosure, ends up being the owner of the property.
So that's what that clause means, that the power of...
Statutory power of sale.
Yeah. It just basically is
Giving
letting...
you the right as a lender to foreclose, and it's basically foreclosure statute
Right.
in Massachusetts.
It's not like the old days, pull a horse cart up to the house and throw all the furniture and
Right.
and tell them you're out.
Yeah.
The king could do that,
Yes.
along with the king's men, but nowadays, altogether different, a lot more difficult.
Some lenders weren't so different in the past few years, but
Now, okay, so we talked about the mortgage, and we talked about the note, but there's the deed.
right.
Now,
Deed is your record that you own the property. So the deed is what the seller will sign at the closing, saying, I, John Smith, grant the property for X price to, Richard Smith, and it'll have the legal description of the property, which is the boundaries of the property, and then that's signed by the seller. It's not signed by the buyer, and it's notarized, and then that deed gets recorded at the registry of deeds, and that's your proof that you own the property. Sort of like the title to your car, that you have the title to. Not need the original deed for anything.
well, I hope you enjoyed the program. It's something that we did a while back, actually. Now that I look at the background with the curtain, but it applies. If you're buying a house, remember the things that were noted by Attorney Abreau. Very important, and it's good to have an attorney. You don't necessarily have to have one, but it's good to be very cautious about selling or buying a house. We're going to end the program. I just want to make a note of an event that's coming up, and this is what they call a Nellie Strong Day. It's going to be Saturday, July 30th at Durfee High School. It's going to start 9 a.m. and run until 4:30 p.m. It's a family event. There's going to be live music, a parade, vendors, games, and I guess what it says and more. So that's Saturday, the 30th. Thank you for watching the show. If you have any questions, give me a call. I appreciate it, and I will see you next time.